Good evening, everyone. Oh, come on. Good evening, everyone. Thank you. My name is Troy McKenzie. I have the honor and the privilege to be the Dean of the NYU School of Law. Unfortunately, one of the downsides of being a new dean is that I sat there waiting for the dean to kick things off before realizing that that was me. I will give very brief opening remarks and then serve as a sort of bargain basement MC throughout the evening. The main content and the main show will be provided by our wonderful list of dedicators this evening. This is the dedication of the 80th volume of the New York University Annual Survey of American Law, dedicated to the Honorable Jed S. Rakoff, U.S. District Judge for the Southern District of New York. And I want to thank all of you for being with us here tonight. Now, as you may know, every year the annual survey dedicates its forthcoming volume to an individual who has made significant contributions to the law. And over the years, we have had the privilege of honoring many distinguished jurists, including Justices Breyer, Scalia, Sotomayor, many other distinguished judges, academics such as Professor Tony Amsterdam, Professor Arthur Miller, the late Derek Bell, and the late Ronald Dworkin. So I am especially delighted, however, that our students chose this year to dedicate this volume to Judge Rakoff. I want to just speak very briefly about the breadth of Judge Rakoff's career and why he is an ideal recipient of this honor. He will be formally introduced in a moment, but let me just say how thrilled we are to have him here. He is someone who has made significant contributions, not just in one part of the law, but across a number of parts of the law. And I also have the pleasure of reading him from time to time in the New York Review of Books. So he's someone who also knows how to translate his learning and his thinking to the broader public as well. At this point, I would like to turn the program over to this year's editor-in-chief of the annual survey, Neil Lockenpaul.
Good evening, everyone. Thank you, Dean McKenzie. Thank you all for coming. My name is Neil Lockenpaul, and I'm the editor-in-chief of the NYU Annual Survey of American Law. On behalf of the Journal, welcome to our annual dedication ceremony, where tonight we're so honored to celebrate Judge Jed Rakoff. For those of you not familiar with the annual survey, our journal was founded now 80 years ago by NYU Law faculty members to serve as a comprehensive, practitioner-focused guide serving developments in American law. Since becoming a quarterly student-edited publication, we continue to serve and bring together the legal community through the practical materials we publish, the symposia we host, and the annual dedication of our forthcoming volume to a distinguished member of the legal community. Each year, we pick a dedicatee who has made a significant impact on American law. And over time, the ranks of our past dedicatees have become a noteworthy club of very renowned individuals. Among them are judges and justices who have had a tremendous impact on our jurisprudence, distinguished scholars and thought leaders, and awe-inspiring practitioners. So tonight, we're privileged to dedicate Annual Survey's 80th volume to Judge Rakoff in recognition of his extraordinary achievements. Any of you who knows Judge Rakoff knows that this was a natural choice for the Journal's board. In just one person's career, Judge Rakoff has spanned all of the categories that our past dedicatees fall into, leaving his mark as a litigator, a jurist, and an academic. After graduating cum laude from Harvard Law, he clerked for Judge Abraham L. Friedman on the U.S. Court of Appeals for the Third Circuit. Then, from 1973 to 1980, he served as an assistant U.S. attorney at the U.S. Attorney's Office for the Southern District of New York. And from 1980 to 1995, he was a litigation partner at two large firms here in New York City. In 1995, he was nominated to the U.S. District Court for the Southern District of New York, and he took the bench the following year. In his nearly 30 years on the bench, he has authored over 1,800 judicial opinions. His caseload is managed at full speed, leading litigators to nickname it the Rocket Docket. His impactful decisions touch areas such as securities law, criminal law, evidence, and complex litigation, among many others. And the judge continues to break new legal ground. Just last week, I was listening to a podcast about a jury trial in which the designer brand Hermes brought a trademark suit for infringement of its Birkin trademark against a digital artist who had started selling Meta Birkin NFTs. And who but a certain Judge Jed Rakoff of the Southern District of New York was presiding over this first-of-its-kind trial, which provided us some of the earliest insight on the interaction between trademark law and NFTs. Beyond the impact of his jurisprudence, Judge Rakoff is an influential legal academic. He's a professor here at NYU Law, as well as at Columbia, Berkeley, and UVA. He has co-authored 5 books and published over 180 articles. I, along with several other members of our journal, took his class action seminar last semester, and this semester, another group of our members is currently taking his Science in the Courts seminar. As our journal's members can personally testify, Judge Rakoff and his piercing on-call questions have left their mark on NYU Law. He has a deep relationship with this school, and as students, we feel it. You're going to hear a lot more about Judge Rakoff from tonight's speakers, but I think it's clear from even a brief synopsis of his career that it serves as a template for those who wish to positively impact their community through a commitment to education, public service, and legal excellence. So next, Dean Mackenzie is coming back to introduce our first speaker, Judge Denise Cote. Once again, welcome Judge Rakoff and all of our wonderful speakers from the Journal and from the entire NYU Law community. Thank you.
Our first speaker will be Judge Denise Cote. The Honorable Denise Cote has served as a U.S. District Judge since 1994, when she was appointed to the bench by President Bill Clinton. And she also regularly sits by designation on the U.S. Court of Appeals for the Second Circuit. She has taught as an adjunct professor at Columbia Law School and at Cardozo as well. And of course, given her tenure on the Southern District, she knows Judge Rakoff very well. So please give a warm welcome to Judge Cote.
Okay, I'm going to start by breaking the mic. There we go. Thank you for this opportunity to join in the celebrations of my colleague, Jed Rakoff. What a joyful task this is for me. Jed came to the bench in 1996 with a distinguished resume, head of the Securities Fraud Unit in the U.S. Attorney's Office for the Southern District of New York, followed by renown as a distinguished criminal defense lawyer while a partner at major New York law firms. That star quality is a hallmark of Jed's entire life. Now, the 20th century gave us several truly great Southern District judges. And whatever your short list is of those judges, Jed is on it. What sets Jed apart as a judge? He thinks deeply about structural issues in our legal system. He has an awesome work ethic, even if he prefers to begin his day at 11 a.m. He is fiercely independent. I am reminded of that Star Trek saying that fits him to a T: to boldly go where no judge has gone before. I'm sure my fellow speakers will give you examples of his independence. There are many. Judge Rakoff also writes prolifically. He literally moves the conversation in our nation in a way very few judges have ever done. And that includes, as you've heard, writing in the New York Review of Books. And by the way, how many judges have had that gig? Jed often writes on the intersection of the law and science. Perhaps that is due to having a father who was a distinguished physician in Philadelphia. Jed comes to the topic of the law and science with credentials to back it up. He is a member of the American Academy of Arts and Sciences, and he was the only federal judge on the National Commission on Forensic Science. I believe we are better off as a nation and a society for having Jed engage publicly in conversations of such importance. Let me turn to Jed's energy and productivity. Some of us consider ourselves active and productive judges, even though some of us are on senior status. And when I say some of us, I include myself. Well, then I have to consider my dear colleague, Jed Rakoff. He puts us all to shame. The SDNY officially emerged from the pandemic last June. At that point, we were all back in our own courtrooms trying our cases where we were used to trying them. But some of us had never stopped trying cases. Why should a pandemic slow us down? We were able to continue doing so because during the summer of 2020, the Southern District of New York reconfigured 6 courtrooms to allow jury trials to continue with everyone socially distanced. I must be frank here. The Southern District was unique in the nation for continuing with jury trials on this scale during the pandemic. And in our district, Judge Rakoff was one of those who led the way. During those roughly 20 months, from September of 2020 to June of 2022, Judge Rakoff tried 8 criminal trials and 3 civil jury trials in our reconfigured courtrooms. No one tried more. And this is just another example of his stamina and productivity. Jed's colleagues know of his love of jury trials and of his generosity. If life or your docket has gotten you in a jam and you need a colleague to take over a case and try it, everyone on my bench knows that Judge Rakoff will take it, no questions asked, and get it tried. Yes, Jed is restless. He is fearless. He is inexhaustible. And not just here, but any place on earth. He is willing to travel on judicial rule of law programs anywhere at the drop of a hat. Now, some of the destinations he's gone to on these trips are not on everyone's bucket list. They include Qatar, Bahrain, Saudi Arabia, and Herzegovina. And this eagerness to travel to out-of-the-way destinations is not new. While at Oxford, for a postgraduate degree in history, Jed traveled overland to India and back on a shoestring. His planning was not perfect, and his meager resources ran out on the last leg of his trip. To find lodging in France so he could cross the ocean, or the Channel, and get back to Britain, he had to convince an innkeeper that he was good for the money. He did a good job, and of course he was. Now, why had Jed gone to India? It was to study why Mahatma Gandhi had been successful in his independence movement, even in areas of the country where that had been, hadn't been expected and came as a surprise. He uncovered copies in India of government documents that the government of Britain had found a way to secret away in Great Britain, but Jed was able to uncover in India. And he put together a compelling thesis that his professor urged him to publish. Now, Jed was moving too fast through life to pause and write a book, but his innovative research, his fearlessness, and his energy have been the hallmarks of his whole life. I have been lucky enough to join Jed on 2 of his trips. And let me assure you, this is not luxury travel. The government pays for coach fare. Jed takes one small suitcase, curls up in a cramped seat, travels overnight, and goes to sleep. Between meetings, he's in his hotel room, working on motions to dismiss or motions for summary judgment or perhaps a speech or a journal article. Again, he's tireless. And what are those meetings like? Often we are meeting with members of a nation's judiciary and tackling problems like the enforcement of arbitration agreements or docket management or judicial independence. But even if you travel with Jed, you are not spared his intellectual rigor. On a recent trip to Istanbul, Jed and I led a discussion with 20 judges from the Maldives and Sri Lanka about contract law principles when applied to international commercial transactions. We had each contributed some of our own opinions to the course materials. And Jed led a rigorous discussion of whether I had reached the right conclusion in one of mine. Thanks, Jed. Before I leave the topic of Jed's travels on behalf of our nation, I must mention his trip to the Green Zone in Baghdad during the Iraq War to meet with Iraqi judges. He donned a bulletproof vest, then he donned a helmet, and he boarded a helicopter. And when they landed, he climbed into an armored car. And when he arrived at his destination, he joined everyone in the mandatory duck and cover drills. What fun. But seriously, Jed, thank you on behalf of everyone here for all you've done for our nation. I will be followed today by Jerry Lynch, a dear friend of mine since our days together at Columbia Law School, and someone who is also known for his intellectual rigor. As you may know, Judge Lynch took issue just a few weeks ago with the way Jed selects a jury. He took such issue with it, he reversed the conviction. I know Jed took this in stride. That's just part of the glorious beauty of our judicial system. It happens to all of us. Indeed, Jerry honored me several years ago when he asked me to speak at the ceremony marking his elevation to the Second Circuit. And then, days before the ceremony, he reversed me. Before I turn this podium over to Judge Lynch, who I know admires Jed greatly, I want to add a personal note. Jed is a generous and kind friend. In moments of difficulty, he can be counted on to offer solace and support. And because it comes from him, it is both genuine and helpful. Jed is loyal. He honors his mentors and makes sure that, as those mentors age, no one forgets their contributions to society. And he is fun. He writes songs. His songs are usually filled with rhymes and puns that don't quite work, which makes them even more enjoyable. And then he sings those songs in a hoarse, sort of off-key way. As I said, he's fearless. And in those songs, he regularly makes fun of judges, usually himself. And he has a loving family, including daughters of whom he is immensely proud. Indeed, he is somewhat of a braggart on that score. Jed and his wife, Anne, and he's found a jewel there, love to dance. They take dance lessons and twirl around the dance floor as often as they can. Thank you, Anne, for helping to keep Jed fit. Jed, this is such a well-deserved honor. Thank you for bringing your prodigious skills to our court and to our nation. Thank you.
Thank you, Judge Coate. As Judge Coate said, our next speaker will be the Honorable Gerard Lynch. Judge Lynch has led a wonderful career in government and in academia, and of course he currently serves as a judge on the U.S. Court of Appeals for the Second Circuit, to which he was appointed in 2009. Before that, he had served for 9 years as a judge on the Southern District of New York. So please welcome Judge Lynch.
How did I forget the songs? That wasn't in my thing. And it's odd because just this weekend I watched the Weird Al Yankovic story. And Jed is really in the same tradition. As Jed, who is a great sports fan, knows, in professional sports, the greatest athletes don't always make the best managers or head coaches. And some of the best managers and coaches were not outstanding players. Now, the analogy to lawyers and judges is not perfect. Few federal judges achieve the bench after a career in practice that is confined to the minor leagues. But I'm afraid it is true that not many judges were in the absolute top echelon of star litigators. Perhaps the difference between Hall of Fame ball players and Hall of Fame lawyers is that star shortstops age out of their superior skills at an age when star lawyers still have many years of exciting and lucrative work ahead of them, which reduces their incentive to seek a judicial appointment. But today, we are here to honor one of the exceptions. Before Jed Rakoff took the bench, he was already a superstar lawyer. When I was a young federal prosecutor in the early 1980s, Jed, who was still on the rise in his profession, if already old by the standards of the NBA, was also short by the standards of the NBA, was remembered in the United States Attorney's Office for the Southern District of New York as the gold standard of AUSAs, a pioneering leader of the office's elite securities fraud unit. After leaving the office, he quickly rose to the very top of New York's white-collar criminal defense bar, establishing that standing practice. Now, people keep talking about at distinguished law firms, they don't say the names. First, he was at Mudge Rose. This is a law firm that lasted from 1869, but only survived a few years after Jed left in 1990. Later, he was at, and by the way, that's a firm that was once Nixon Mudge Rose. It survived the loss of Richard Nixon, but not the loss of Jed Rakoff. And then later at Fried Frank. While still in practice, Judge Rakoff had already shown a penchant for pursuits that were even less lucrative, but more heady than even high echelon law practice. He has taught, as you've heard, at any number of law schools. I don't know how he manages to be a professor at 4 different places at once, but I guess we heard all about his energy, so that must do it. For many years, he taught at a certain law school not too far north of here. And even as a young prosecutor, he took the time to draft a law review article. Now, that article, the Federal Mail Fraud Statute, Part 1, shows Jed's gift for writing. Its opening words rank with the greatest and most quoted opening lines in the legal literature. It's sort of the legal equivalent of "Call Me Ishmael," or "It's a truth universally acknowledged that a single man in possession of a good fortune must be in want of a wife." It goes like this: "To federal prosecutors of white-collar crime, the mail fraud statute is our Stradivarius, our Colt 45, our Louisville Slugger, our Cuisinart, and our true love." Well, at least it used to be among the most quoted openings of law review articles, but I suppose it gets cited a little less frequently since the Supreme Court started treating Jed's Stradivarius the way Jimi Hendrix treated his own guitar at Monterey, and hurling Mariano Rivera quality bat-breaking cutters at his Louisville Slugger. After this term, the mail fraud statute may turn out to be the prosecutor's kazoo, their wiffle ball bat, their BB gun, their wire whisk. Perhaps that is why we are still waiting for the mail fraud statute Part 2. Since becoming a United States District Judge in 1996, Jed has established himself as one of the deans of the trial bench in the great tradition of Edward Weinfeld and Leonard Sand, only with a slightly greater flair for publicity. Somehow, Judge Rakoff's fame and the esteem in which he is held by judges and lawyers alike seems to have penetrated even the world of inanimate objects. I have in mind the wheels from which random assignment of cases to judges are made in the SDNY. Those instruments of random selection seem to have decided that Judge Rakoff's name should be spit out whenever a particularly sexy or difficult case needs to be assigned. Judge Rakoff's brilliance and practical common sense as a trial judge is clearly respected by the courts of appeals. Jed is regularly tapped to sit by designation on his home court of appeals, my court, the Second Circuit, to give us the benefit of his wisdom, learning, and experience. That's not entirely rare, of course. As any district judge will tell you, even though a district judge's job is much more demanding and time-consuming than the more leisurely pace of appellate judges' work, we seem to enlist district judges to take on additional work helping us out, while only very rarely returning the favor. But what is more unusual is that Judge Rakoff's reputation extends all the way across the country. His travels go not only to such exotic places as Kazakhstan, but to such even more exotic places as the Ninth Circuit. Even more remarkably, it's not only the judges of the Ninth Circuit, the assignment wheels there also seem to hold Judge Rakoff in high esteem. Let me explain. The late Justice Scalia, who, as we've heard, is a predecessor of Jed's as an honoree by this publication, used to periodically recognize a district judge with what he called, and I'm sure I'm going to massacre the Italian, the E pur si muove award, named for Galileo's famous remark. I'm sure you all know the story, even the law students. You're all bachelors of arts, right? So you're educated people. You know this story. When Galileo was forced by the Roman Inquisition to recant his theory that the earth moved around the sun, he capitulated, but is said to have muttered under his breath after capitulating, "E pur si muove," and yet it moves. Justice Scalia's award went to a district judge who was reversed by the Court of Appeals and later vindicated when the Supreme Court in turn reversed the Court of Appeals. Even though that happened to me once, a little case called Twombly that you may have heard of, I never quite understood why being agreed with by a majority of the Supreme Court constitutes vindication. Anyway, Judge Rakoff did rather better than that. After the Second Circuit rendered a decision in an insider trading case that Judge Rakoff disagreed with, he went off to the Ninth Circuit, got randomly assigned to a case that presented the same issue, persuaded the panel to reach the opposite result in an opinion by Judge Rakoff, creating a circuit split that the Supreme Court resolved in his favor. The lesson to be drawn here is that we should have Judge Rakoff sit with us even more often, bringing him inside the tent to dispense his wisdom outward toward the rest of the world, rather than leaving him to direct his stream of legal learning back in upon us. Maybe I should have worded that sentence a little differently. Jed has continued to diversify his legal pursuits beyond law practice and the bench. I've already mentioned his extensive teaching. Generations of law students at Columbia have benefited from the course he taught with my Columbia colleague Jack Rakoff for many years, called The Black Letter Law of White-Collar Crime. Jack is also a pretty good wit, so I can't say for sure that that's another example of Judge Rakoff's penchant for the turn of phrase. In fact, once when Jack was on leave, Jed even taught that with me. But I do detect the note of the Rakoff Stradivarius in that phrase. And you should not mistake his offerings, and I gather the NYU law students also do not, for some collection of war stories and practical advice from a distinguished lawyer dropping in on the academy from time to time. Courses in white-collar or federal criminal law are fairly common today, but they were not when the Coffey-Rakoff partnership began. Both that course and the judge's even more innovative seminar on the intersection of civil and criminal law have been rigorous intellectual offerings that challenge the conventional wisdom and bring new insights into the classroom in the best traditions of the legal academy. In recent years, moreover, as you've heard, Jed has broadened his intellectual offerings beyond the law schools, becoming a regular contributor to the New York Review of Books. And I assume that our audience are all familiar with that publication, with its readership among the intellectual elites, and its lengthy scholarly reviews of both general interest and university press books. The reviews are so long and scholarly that many of us who want to pretend to be familiar with cutting-edge scholarship in the arts and sciences keep up with many fields by skipping the books and just reading the reviews in the New York Review. In fact, those reviews are sometimes so long that I have often toyed with the idea of starting a new publication, the New York Review of the New York Review of Books, which would commission experts to summarize, condense, and comment on the articles in the New York Review. By the way, I have to thank Jed's writing in that publication for giving me a moment of fame in the broader world of New York intellectuals. There's another frothier publication followed by pretentious New Yorkers, the aptly named New Yorker. And as you all know, just as once upon a time men used to say they read Playboy for the articles, people say they read the New Yorker for the articles, but really they read it for the cartoons. As far as I know, my name has appeared in that magazine only once, but in the most important feature, in a cartoon. The cartoon is by Harry Bliss. It shows a child at dinner with her parents, telling them about her school day. The caption says, "And then he paraphrased New York Judge Gerard Lynch when he said our country has an overinflated system of incarceration that is far too punitive, disproportionate in its impact on the poor, exceedingly costly, and largely impotent in reducing crime." Anyway, that's what I learned in school today. So I was very excited to be quoted in a New Yorker cartoon, so I contacted Mr. Bliss, the cartoonist. I said, "I'm amazed. Are you a regular reader of Criminology and Public Policy, a somewhat obscure legal academic journal in which I had published a brief comment in a symposium on the work of another legal scholar?" "No," the cartoonist told me, "I found that quote in an article by Judge Rakoff in the New York Review of Books." Now, don't get the impression from this that Jed's articles in the books are mere popularizations of the work of, shall I say, more distinguished scholars. Quite the contrary. Jed's work does a job much more challenging than that taken on by most who publish in law reviews. His articles are designed not only to explain, but also to question complex legal concepts and practices for an audience of highly sophisticated academics, writers, and other intellectuals at a level that enables accurate and nuanced public debate by non-specialists. That is a tremendous accomplishment and a tremendous intellectual service. For those of you who are less familiar with the New York Review, but are familiar with the accomplishments of the NYU law faculty, I should note that among those who have held the legal gig at the New York Review of Books as go-to contributors are your own Jeremy Waldron and the late, great Ronald Dworkin. That's a pretty tough crowd, in which Judge Rakoff amply holds his own. The bottom line, of course, as you've heard, is that Jed Rakoff has had an extraordinarily broad and deep legal career. Outstanding practitioner on both sides of the criminal bar, eminent full-time trial and part-time appellate judge, brilliant teacher and academic commentator on the law, a true decathlete of the law, exactly the sort of lawyer you all should aspire to become, but few will succeed. Finally, as you've also heard, I recently wrote an opinion reversing Judge Rakoff in a criminal case. So, Jed, I hope this affectionate, mostly sincere, at least partly accurate tribute makes up for that. So please don't go out to the Ninth Circuit and engineer a Supreme Court repudiation of my opinion. Congratulations, Jed. This is a very well-deserved honor.
Always make your own magic. Our next speaker is someone who is very familiar in these halls. Indeed, he is my former student from my second year of teaching. I have the pleasure of introducing Matt Shahabian. Matt went on to clerk after graduating with honors from this law school for Judge Rakoff, and then went on to clerk for the late Chief Judge Bob Katzman of the Second Circuit and Justice Sonia Sotomayor of the Supreme Court of the United States. He is currently an assistant U.S. attorney here in the Southern District of New York. I was actually fortunate enough to attend Matt's wedding several years ago, at which Judge Rakoff presided. And Judge Rakoff did not merely preside, but as was hinted at earlier, when the music started, he and his wife were the first people on the dance floor, and they can move. So please welcome Matt Shahabian.
Thank you for the introduction, Dean McKenzie. It's wonderful to be back on campus this evening to honor Judge Rakoff. I think I'm required to start by noting that my views do not necessarily represent the views of the Department of Justice or the United States. And my guess is the views of the Department of Justice on Judge Rakoff vary from lawyer to lawyer. When a lawyer learns that I clerked for Judge Rakoff, I typically get one of a few reactions. First, man, what a tough judge. That one is sometimes expressed a little more colorfully. Second, can you believe he makes us call chambers before we file routine motions? And third, how much does he pay off the clerk's office to get all the good cases assigned to him? I'll start with the last one. And I did not see Judge Lynch's remarks before I wrote this. The wheel is not rigged. I see some skeptical looks. There's no way one judge on a court with 40 district judges should get randomly assigned that many high-profile cases. And they're right. Random chance doesn't explain it. So, why? Well, that's your answer. Why? Judge Rakoff's superpower is simple. He always asks why. Even when the question seems minor and unimportant, even when something has been done that way for years. Why should he put a judicial stamp of approval on an SEC settlement when the company just pays a slap-on-the-wrist fine and nobody is held accountable? Why is the federal death penalty constitutional as a matter of procedural due process? Why can't jury selection be completed in under an hour like it's a speed dating event? I'm told now that you can't do that one anymore, Judge. I'm sorry. David Hume has nothing on Judge Rakoff. The judge has never seen an is and thought, that's an ought. Woe to the AUSA who says he's taking a position because it's office policy and can't explain why that policy makes sense in that particular case, especially if that policy relates to the sentencing guidelines. On every case, every issue, the judge always pushes the parties to look past standard ways of thinking about the legal problems and ask why. Is this just? Is this equitable? Is this efficient? Is it the right way to run our railroad? High-profile cases are not magnetically attracted to Judge Rakoff. He's not looking for attention for the sake of attention. His cases become high-profile because he draws our attention to important issues that have gone unnoticed or ignored. What I saw my year clerking, what we all see year after year and case after case, after 27 years on the bench, is a judge whose dedication to justice is carried forward by his willingness to fundamentally reassess every piece of jurisprudence in any case, big or small. It's a willingness to try to make things better, even if he's later reversed or makes mistakes in the process. And if you'll allow me a brief tangent on the topic of mistakes, one of my sharpest memories as a law clerk is the first time I made a substantive mistake in an opinion. I remember realizing what had happened after the opinion had gone out, realizing that it was significant, and not really knowing what to do next. It was late in the evening. The judge was still in his office, of course, and so I collected myself and I went to the judge's office to explain how I had messed up. And after I finished explaining the issue, the judge looked at me and said, "Well, the party should have caught this, but we can fix this." And then he explained his elegant solution. And then he said, "Plus, if it doesn't work, that's what the circuit is there for anyways." And then he laughed. And that moment had a profound impact on me as a law clerk fresh out of law school. It brought home that law is a fallible enterprise staffed by fallible people. But that doesn't mean we don't try or put our heads in the sand or stop asking why or become too afraid to search for the right answer in difficult cases. The judge's questioning of established norms isn't limited to the important substantive legal issues of the day. As the practicing litigators in this room well know, it extends to procedure, too. Setting less than 6 months for discovery to be complete in a civil case, followed by a prompt trial. Again, the judge asks, why? Why longer? Why stay discovery in favor of settlement negotiations or criminal prosecution? What interest does that serve? Calling into chambers for every motion. Again, that's an answer to a why. Why should every discovery dispute turn into pages of pointless letter briefing when we can resolve most disputes over the phone? Even on the basic development of the law, and I don't know if this has been studied, but I have found that if I have a question about some basic procedural issue in the trenches of litigation, discovery, protective orders, things like that, I'm typically going to find a Judge Rakoff opinion on this, and it's typically going to be the one other judges are citing, even at the circuit, when the same issue comes up again. Again, that's an answer to a why. Why shouldn't I have oral argument on every motion? Why shouldn't there be written opinions on basically every issue? Of course, all these procedural innovations can make lives uncomfortable for lawyers practicing before him, sometimes for his clerks. But the judge has said publicly he's hard on lawyers because the goal of justice isn't to make lawyers' lives comfortable, it's to make the legal system as accessible, as fair, as just as possible. Justice delayed is justice denied. And I saw, all of his clerks saw, how seriously the judge takes that issue in his own work. Every day when he stayed late into the evening to finish reading bench memos and briefs before going dancing with his wife. Every Monday morning when we would come into the office with stacks of draft opinions and supporting materials weighing down our desk chairs with cryptic notations like good and very nice on the draft that we would try to sort into some relative rank order that never made sense. I also saw how the judge's passion to push the cause of justice forward extends not only to the development of the law, but to the profession. He asks his clerks to not just think about why, but what and how. What can you do to give back to the cause of justice? How can you improve the system? If a clerk declines his suggestion to apply to the U.S. Attorney's Office, the greatest job other than my current job, he would say, then he will do whatever it takes to help his clerks find their path to public service, in government, public interest jobs, in private practice, because he wants us to be enlisted in his mission of advancing justice as part of the profession. I am proud as a Rakoff clerk to see that the 80th volume of the annual survey will be dedicated to him. But one evening of tributes, one volume can't possibly capture the measure of the impact that judges had on the law, on the legal community, especially here in New York, and on his family of law clerks. And on behalf of that family, I wanted to say thank you, Judge, and thank you all.
Thank you, Matt. I would now like to introduce my colleague, Erin Murphy. Professor Murphy is a professor here at NYU Law who studies technology, forensic evidence, and the criminal justice system. She is a nationally recognized expert in forensic DNA typing, and her work has been cited multiple times by the Supreme Court of the United States. And Judge Rakoff has also written on similar topics. In fact, as was mentioned, he teaches a class action seminar here and also a seminar on science and the courts at NYU. Please welcome Professor Murphy.
Thank you. So I have to say, it's no easy feat to do sweep here, following two eminent jurists, and even worse to follow Matt, who literally makes a living making persuasive arguments for people. But I do at least have the privilege of the last word, so I'm grateful for that. And if there's one thing that I think I could offer this eminent group, it is my longstanding interest in a topic of great interest to Judge Rakoff as well, which is the use, or perhaps more accurately, misuse of scientific evidence in our legal system. And I will get to that. But I reflected a lot on Judge Rakoff's career as I prepared my remarks for today, and the more I did, the more I saw another, perhaps less obvious thread that ties us together. Now, we've got a lot of prosecutors in the room, but I will say Judge Rakoff and I share something else which you heard mentioned, which is that we both spent a chunk of our career as defense lawyers. And as you know, defense lawyers are a special breed. They're the courthouse mavericks, the pests, the renegades. They get front row seats, especially in criminal cases, to the ugliest parts of the law, not just the victories, some of its excesses, some of its cruelties. And so even while they may love the law, they're never fully enraptured with it. It's a mature love, not a starry-eyed romantic love. They respect law's power, they admire law's mission, but they also always have one eye out for its hypocrisies or its injustices. And they always stand at the ready to hold law to account, even when they stand alone in doing so. And that's the Judge Rakoff I would like to celebrate with you today. The distinguished jurist, sure, but also the defense lawyer, the judge who's serious about law's power and law's authority, how he uses it, how it affects the people that appear before him, and what it means for the greater project of fairness and equality in our society. The jurist who knows that law runs on brains, but justice takes heart and courage. So, we've heard a lot about the brains, the heart, and the courage in an array of different fields, but the one that most resonates with me is, of course, criminal justice and forensics in particular. When the Supreme Court issued its landmark 1993 opinion in Daubert versus Merrill Dow, it made a lot of lofty statements about safeguarding scientific integrity and rejecting junk science in cases, but it seemed to do so wholly forgetting about the criminal legal system. Indeed, after remand, the Ninth Circuit wrote an opinion that cast doubt on a lot of sciences, and it specifically said that in determining whether proposed expert testimony amounts to good science, we may not ignore the fact that a scientist's workplace is the lab or the field, not the courtroom or the lawyer's office. But then it dropped a footnote to that sentence and said, essentially, but see criminal forensics. In other words, if it's criminal forensics, it's absolutely fine for this science, or so-called science, to be made by police departments or prosecutors' offices, rather than in laboratories or academia. And in the decades since Daubert, most courts have done just that. They've subjected scientific evidence in civil cases to some degree of scrutiny, while also giving criminal forensics a free pass. But not Judge Rakoff. Take his trailblazing opinion in the United States v. Glynn case, in which the government sought to introduce a ballistics expert who would testify that, quote, to a reasonable degree of scientific certainty, which is a commonly accepted phrasing that also happens to lack any basis in science, the bullets match the firearm. When met with this absurd, very common overclaim, Judge Rakoff actually applied the Daubert standard, something itself that's already a bit of an unusual move, and, quote, very quickly concluded that whatever else ballistics identification analysis could be called, it could not fairly be called science, and thereby limited the proposed testimony. He carried this capacity to take law's mandates seriously, to refuse a wink-wink, nod-nod of we've always done it this way, it's just criminals, who cares, and instead actually re-examine long-standing, well-accepted orthodoxies throughout his career. And you can see it in his role as a reviewer of the landmark 2009 National Academy of Sciences report on strengthening forensic evidence, which called many of these practices into question, or in his work revising the Federal Judicial Manual on Scientific Evidence, or perhaps most importantly, his role as a senior advisor to the President's Council of Advisors on Science and Technology that produced a landmark 2016 report. In each position, he was undaunted by powerful forces that like to shroud the problems in forensics in darkness, problems that call into question familiar disciplines like hair, fiber, bite mark, fingerprints, and others. And he continued to use his voice, and by extension, the unique authority of his office, to shine a light. Ultimately, this critical, in both senses of the word, work led to the formation of the National Commission on Forensic Science, which, as you heard, precisely one judge, federal judge, was invited to join, and you already know who. Over its 4 years of service, the NCFS voted on upwards of 40 recommendations. And as someone who followed the commission's work very closely, I want to underscore how important a role Judge Rakoff played and highlight two of his particular contributions. First, to set the stage, the NCFS had 7 different subcommittees, and Judge Rakoff co-led one, the Reporting and Testimony Subcommittee. And consistent with the legendary work ethic you've heard described, that committee alone produced 9 separate reports, almost a quarter of all the reports generated by the entire commission, and shepherded 3 critical recommendations to acceptance. One of these, by the way, was a recommendation that harkened back to that Glynn case. It forbade forensic experts from using the made-up and misleading phrase of reasonable degree of scientific certainty in characterizing their opinions before judges or in reports or before juries. The second contribution is a little more abstract, but I'm going to tie it to a concrete example. And that is that throughout all the commission's conversations and discussions, Judge Rakoff repeatedly served to reorient everyone, lawyers and non-lawyers alike, to the reality of how forensic evidence is processed in criminal cases. That is, in formulating the rules around evidence, it's really easy to fixate on the idea and the ideals of the trial. After all, trials, juries occupy a huge mythos in our system. But that often means that the systems and protections that are put into place don't end up mattering much, if at all. Because as we all know, very few cases go to trial. In some places, 1%, 2%, 3% of cases. And most criminal attorneys, both prosecutors and defense lawyers, are overworked and under-resourced. The ideal of the preparation for the trial is a poor match for the reality of how our system adjudicates its cases. So if we're going to have an impact, we have to keep in mind that the rules should be made not for trials, but for the much less idyllic conditions under which our system of justice works. The hallway plea negotiation, the lay reader of a report with no access to expert assistance, the rapid triage of scarce resources. And in the commission's hearings and in his public comments, Judge Rakoff repeatedly reminded everyone of this and exhorted everyone to craft rules to that reality. He made it a mission to provide criminal defendants with the same degree of expert disclosure pretrial that's afforded to civil litigants whose liberty is not on the line. And it's not just because there's no legitimate reason to withhold expert evidence, which doesn't involve concerns about tampering or safety. It's not just because expert disclosure allows the integrity of scientific evidence to be better safeguarded. It's also because, built on a system of plea bargaining, full disclosure is necessary if we're to inch the plane on which those negotiations take place even a little bit closer to the angle of justice. Now, I will forgive you all if you think expert discovery reform does not sound like a super scintillating or meaningful reform topic. It's not as exciting as what I heard is one of your other crusades, which is making sure everyone says Daubert correctly, not Daubert. But let me tell you that there was a number of people who understood how important this was. The DOJ, for instance, understood how important this was. Because as some of you may know, once the subcommittee embarked on the path of its recommendations on discovery, the DOJ sought to shut it down. And that's when Judge Rakoff resigned his position, noting that the DOJ was placing strategic advantage over a search for the truth, rather than continue on without addressing this most important issue. Everyone remembers Sally Yates as a hero of the resistance, but I will always remember her as the person who cowed before the mighty wrath of Judge Rakoff, the one who begged him to return to his role, which he did. And there is only one member of the commission whose public resignation could have brought about that result, could have brought about the recommendation that then passed to give pretrial disclosure. Again, you already know who that is. Judge Rakoff managed to get this disclosure requirement out just before the commission came to an end. But suffice it to say that his passion for the responsible and accurate use of scientific evidence in our legal system has in no way abated. It's evident in a recent case limiting the testimony of a supposed expert in cell site location who was neither a scientist nor an engineer and could provide no detail about his methodology. It's evident in his reluctant admission of a supposed gang expert, citing the unequivocal support of the Second Circuit for such testimony, but not without adding an article that calls the methodological basis of that testimony into question. It's evident in a case sitting by designation on the Second Circuit that vacated a conviction on ineffectiveness grounds, citing in large part the attorney's basic failure to challenge dubious eyewitness identification testimony. And of course, it's on virtuosic display in his much heralded and courageous opinion in U.S. v. Quinones. And I do not speak Italian, but e pur si muove, or what have you on that one. So lastly, I should say, Judge Rakoff's influence extends far beyond the formal halls of justice. As you heard, he's a regular contributor to the New York Review of Books. And those essays have spawned a book of compiling them called Why the Innocent Plead Guilty and the Guilty Go Free. And there he brings his expertise as a judicial officer, as a person specially learned in the law, to help diagnose what ails our system and propose concrete treatment. What is striking about these essays, when they are collected together in his book, is his direct juxtaposition of the harshness of mass incarceration alongside the increasing impunity of elites in our society. He follows a chapter on draconian sentences meted out to poor people and people of color, with a chapter addressing why, quote, not a single genuinely high-level executive was successfully prosecuted in connection with the Great Recession of 2008. He's not afraid to call out the government's role in enabling financial fraud, just pages after he calls out the government's role in enabling the most troubling aspects of our charging and bargaining system. The contrast is striking. It's this dual reality of our system's mercilessness and its impunity that sows doubt in the rule of law's legitimacy and credibility, and deepens the sense that there's two systems of justice in our country. Without judges like him and the courage he has to call it what it is, we know that law's capacity to bind a diverse and sprawling body politic will fail. To live up to its ideals, we cannot be afraid so, even when it makes some of us uncomfortable. I want to close by saying that in preparing for this tribute, I reached out to a number of friends and colleagues who have either worked with or practiced before or served alongside Judge Rakoff. One echoed a blog post that I had also seen, which was, Judge Rakoff is never boring. Another cited his capacity to deliver a lethal wisecrack. But my favorite reply was from a fellow criminal defense attorney, actually, who told me a tale of a complicated matter in which, as you heard, Judge Rakoff demanded the attorneys produce briefings very quickly in order to ensure that the liberty of the person was honored, showed more engagement and expertise in one hearing, my friend said, than many judges, present company accepted, of course, show all year. And he ended by saying, the thing about Rakoff is that he's a singular and powerful intellect, and he's in complete control of his court. He makes you work hard, and he enjoys debate, so you have to be ready for just about anything. He puts you through the paces. Nothing is given. You have to earn everything. I sometimes disagree with him, but not often, and I really enjoy practicing in front of him. He makes you the best lawyer you can be every time. Thank you, Judge Rakoff, for your extraordinary career on the bench, for your courage, and for what I can safely say is, not with a reasonable degree of lawyerly certainty, but with absolute confidence, a profound and important impact you've had on advancing the cause of a safe, fair, and just society. Thank you.
Judge Rakoff and Dean McKenzie, if you could join me up here for a moment. Judge Rakoff, on behalf of the NYU Annual Survey of American Law, I would like to dedicate our 80th volume to you in honor of your contributions to American law.
Now it's time for rebuttal.
Yes. So, first I got to get out my reading glasses. I want to express my immense thanks to Judge Lynch, Judge Coate, AUSA Shahabian, Professor Murphy, and Dean McKenzie for their extremely kind remarks. I hope someday I'll get to meet the guy they just described. In the meantime, my wife will now come forward to give the rebuttal. I am also tremendously honored that Neil Lockenpal and the other editors of the Annual Survey of American Law have chosen to dedicate their 80th volume to me. The annual survey is renowned throughout the legal world for its high standards and deep insights, and I hope this dedication won't compromise its reputation. But I do promise to read the entire 80th volume, even the footnotes. Further, I want to express my great appreciation to those of you who are kind enough to come to this program this evening. I see in the audience many close friends, many brilliant law professors and law students, and many very distinguished judicial colleagues. Each of you is a superstar in your own right, and I am flattered beyond words that you are here in attendance. I also want to thank my law clerks, a number of whom are here tonight. They, along with my superlative courtroom deputy, Linda Katowski, who is also here tonight, bring total joy to my life as a judge. Finally, I want to thank my wonderful family, and most especially my lovely wife, Anne. Anne is the kindest and most generous person I know, as exemplified by her putting up with me for 48 years. Incidentally, I can't help this, I feel compelled to mention that Anne and I will be participating in August in an international amateur ballroom dancing competition in Rome, Italy. We expect to do quite well, provided the other couples are more than 90 years of age. Anyway, I'll send you all the video. But now, I hope you will forgive me if I take a moment to say something serious. For many of us, I suspect, these are somewhat grim times. Perhaps not as grim as a few years ago, but still pretty grim, as our great nation goes through a crisis of values. For those of us who have been on the federal bench for many years, a contributing factor to this grimness is the fact that our leaders, the justices of the Supreme Court, now include a majority who seem oblivious to many of the dangers that we as a society face, oblivious to everything from police misconduct, to unwanted pregnancies, to global warming. Most especially, they seem oblivious to the predictable consequence of their extreme interpretation of the Second Amendment, thereby facilitating the ever easier obtaining and carrying of firearms and the concomitant increase in crimes of violence and mass murders. I never thought I would see the day when the Second Amendment, which on its face seems limited to state militias, would be used to bludgeon to death even the most modest attempts at meaningful gun control. Is not protecting people from violence the first duty of any government? Yet, last term in the Bruen case, the Supreme Court held that this duty is largely irrelevant when it comes to assessing the constitutionality of gun control legislation. To be frank, I am utterly astounded that a majority of the Supreme Court could find it in their heads and their hearts to prevent our state and federal governments from carrying out their most fundamental duty of protecting you and me and all of us. And look what's happened since. Fortunately, history provides many examples of judges changing their views over time in reaction to raw experience. And so I remain cautiously optimistic that some of the more ideologically focused justices of the Supreme Court, who I am nevertheless sure are people of goodwill, will eventually moderate their views in the face of the facts. Perhaps we judges on the lower courts can assist in that moderation by letting our own views be known, even as we carry out our own basic duty of applying the law however it is given to us. Well, forgive me for laying this on you. None of this can detract from the joy I feel that you're honoring to me tonight, and you have my heartfelt appreciation. Thank you so much.
Of course, he ended on a bland note. Judge Rakoff, thank you once again for accepting this honor and for honoring us with your presence and your words this evening. This has been an extraordinary occasion. I also want to take a moment to thank each of our distinguished speakers for coming to NYU this evening and for sharing their words as part of this very special tribute to Judge Rakoff. And last but not least, I want to thank the students at the annual survey for choosing Judge Rakoff and for convening this celebration. And I will conclude this occasion with a reminder that we will have some refreshments over there. Please stay. Thank you.